Hello and welcome to this special live today, Monday, September 12th, 2022. My name is Neha Mahajan. I'm the Business Development and Outreach Manager at Chug LLP Attorneys and CPAs. The reason why we are live today is because Department of State announced their Visa Bulletin for October of 2022. And if you are unaware, the dates have retrogressed, leaving a lot of people heartbroken, nervous. They don't know what's going to happen next. And that's exactly why we decided to go live today to answer some of the most pressing questions that you may have. Since October of 2020, we've seen a fast forward movement of dates in the Visa Bulletin, and a lot of people got their green cards, especially those who were heavily backlogged for countries like India, China, and Philippines. It was such a fresh breath of air. But October's Visa Bulletin has left a lot of us feeling sad and depressed. Why is that so? What is a retrogression? What does it mean for you if you're on H-1B waiting for your green card? What does it mean for you if you have already applied for 485 adjustment of status? What's going to happen to your case? What's going to happen to your kids? Are they protected under CSPA? We are going to be talking all about it. Joining me today is our immigration lead from our Santa Clara office, Deepika Singh, and our partner attorney, Diya Mathews, from our Edison, New Jersey office. Hello there, ladies, and welcome.
Thank you, Neha.
Hi, Neha.
Hi, Deepika. Yeah, all right. So, Diya, there seems to be a commotion. Like Twitter is on fire. A lot of social media platforms are on fire. People are... They are clueless right now. They don't know where to look for the right kind of information, especially when this October 22 Visa Bulletin. So what's going on? Why is there such a commotion? If you could give us a little bit of detail on what's happening, that'll be helpful.
Right, Neha. I guess there is a lot we could say about our immigration system, right? The US immigration system, and especially when it comes to the employment law categories. I think it's never really been fair for people born in India, right? Just because of the limits, the per country limits, and just the sheer unpredictability of it. So we had good news in October 2020 because USCIS suddenly announced that they have a large number of visa numbers available, and I guess Deepika will talk more about the reasons behind it. But October 2020, it seemed like the floodgates had opened up, and everybody, a lot of people were eligible to file. So they rushed in, they did the downgrade, the EB3 downgrade, did the adjustments, paid a large amount of money in filing fees and attorney fees and everything to get that done. And then, after a few months, we were told, EB3 is backlogged. But EB2 is still good, so try and get back into the EB2 queue. So then the question for a lot of people was, should we refile the adjustment application based on the EB2 I-140, or should we just ask USCIS to interfile? And finally, USCIS came out with some clarifications. So it seemed interfile was the way to go. And they encouraged people to do the interfile. They said, hey, look, we have all these visa numbers in EB2, unprecedented numbers, and anybody. So we encourage anybody who is eligible for an EB2 or an EB1 to go ahead and do that. Our clients did that. And then they had announced that, this is probably going to be until the end of September 30th, right? The end of the fiscal year. So, get everything done before that. But I think that gave us hope, right? All of us were expectant that all these people who had filed could expect to get their green cards, their permanent resident status by the end of September this year. Unfortunately, what has happened now is that in the first week of September, they announced that they have actually used up all the visa numbers for this year, and I guess they hit the limit sooner than they expected. So no more green cards. And so the question now is, what about all those people who filed for their 485 and they haven't got their green card? Are they going to get it? Is there still a chance that they'll get it before the end of the month, or will they be stuck again in this loop? So so that's what we'll discuss today.
Yeah, right. And there are a lot of I was looking at some numbers, and I know we don't want to go in too much into numbers because Well, there's not a lot of clarity from USCIS about it, but USCIS was essentially saying that they had 281,507 visas that were available until September 30th. And suddenly now, when the visa bulletin came last week, literally a few days ago, they're saying, well, now all those visa numbers are gone. They are no longer available. So just I find it a little confusing. I think every year, the numbers that are allocated for employment-based categories is 140,000, right? Under EB1, EB2, and EB3. So how is it that USCIS had 281,507 visas available? Where did these numbers come from? Deepika, do you want to take that up or?
Yeah, sure. So, Neha, I'll tell you how the system actually works.
Yeah.
So, whatever is the excess from the EB4s and the EB5s, that basically what USCIS does is they adapt a fall up and a fall down method. And those visa availability, whatever numbers are available, they flow down first to the EB1s. And then whatever is remaining from EB1s flows down to EB2. And then the EB2 flows down to EB3. So that's basically the fall down method they use. And that's how visa numbers actually move across all these categories. So the 140,000, which we are talking about, 40,000 are dedicated to EB2 category and 7%. So India has about 7%. So every country has about 7% of those visas. And that kind of comes down to 2,800 of total numbers, which definitely gets absorbed easily. I mean, I'm sure there is more requirement than the number of visas available. So I think that could have been one of the reasons why the visas probably are not available this year or got over for fiscal year. But that's basically how the flow down and flow up actually happens. And we'll see when whether for the next fiscal year they'll have some extra numbers available and how does the flow up and the flow down work.
Right. Dear, one word that I hear on social media platforms, people complaining, especially those on the green card backlog, is wastage. They always keep blaming USCIS that, hey, USCIS, you've wasted these many numbers of visas this year and that year. Where are these numbers coming from? What is wastage? And do you think USCIS really did waste any numbers this year?
Yeah, so that's actually related to what Deepika was saying about the fall down and, the allocation of unused numbers from certain categories to the others, right? And I believe as a result of some of the statistics which have been released by USCIS recently, people have figured out that they actually failed to apply some of the numbers in the last year. If they had correctly applied the numbers, then there would have been some more visa numbers available in 2021. And so that's what they're referring to as wastage. And, it's unfortunate that in this day and age, we are working with a system where even USCIS does not have complete visibility on the visa numbers, right? Because they have to ping the database. That's what they say, that they have to kind of take the visa number from the Department of State. And then because of various, issues with the whole immigration system, like the fact that, the same person might have filed in multiple categories, right? And then there are concurrent filings, there are separate filings. So because of all of these reasons, they are never able to accurately estimate how many visa numbers are available and how many have been used up at any given point of time. It's like the whole Heisenberg principle, that I think we studied in high school. Like you can never predict the speed and the location of a molecule at the same time. So it's, I feel it's kind of like that with the USCIS, that they never know like exactly where they are. And it makes sense, considering we know that they're at the mercy of Department of State. It does make sense what they're saying, that they don't know exactly what the usage is.
Right. But it's such a shame. I feel sorry, Deepika. I just want to make a comment. I mean, it's such a shame that, in a day and age where we're using AI, we're thinking of landing on Mars and whatnot. We are unable to, USCIS, here's this agency that literally determines the fate of millions of people in the United States of America, is unable to keep a track of how many visa numbers they're using up every year. It's just beyond me.
Yeah. And just to add, Neha, when we talk about visa numbers, the entire family is counted towards that number, Right. So every derivative. So if there's a principal applicant and he has another 3 family members, they are all counted towards that 2,800. So there is more requirement than the numbers available. So we have to even understand that, right?
Right.
So
All right. Yeah. So I just want to reiterate here that we are live on Facebook, YouTube, and LinkedIn. We typically go live on Thursdays. Well, that's going to happen this Thursday also, but we are going live today, Monday, because we're discussing the October Visa Bulletin, where the dates, the visa availability dates have retrogressed to April of 2012 in the EB2 category for India. So we're discussing that. What does it mean for you? What does it mean for your family? Will you get your green card this year? Will you have to wait any more longer? We're talking all about it. So if you have any questions for us, send them to us in the comment section or write to us info@chugh.com. That's info@chugh.com. Also a disclaimer, the discussion today is for informational purposes only. We're just discussing the visa bulletin. This does not create an attorney-client relationship, so there is no legal advice happening here. So I really want to, talk to you, Deepika. When the visa bulletin was first released back in October of 2020, right? That was such a relief for many in the EB3 category, right? And then many downgraded, and then like Diya had mentioned before, there were a lot of interfiling done in the following months. Many received their green cards. Many are still waiting for final adjudication, which means they've only received their EAD or AP cards. And then USCIS suddenly changed their mind and just started releasing EAD cards and not the AP combo card, right? And there are also many scenarios where the primary applicant has received their green card, but not the dependent. Right? There's just so much mishmash happening here. There are multiple scenarios where people are still waiting for answers from USCIS about their case. And now this retrogression. Right? So it looks like their life will again be in a limbo. What do you have to say, especially about those who have the EAD AP card? What do you have to tell them?
So AOS has always had a history, right? 2007, they made the dates current. Many people filed their AOSs. And probably by 2012, people even got their green cards. Then again, 2012, they moved some dates for the Indian nationals. And then again, people filed the green cards and people eventually got. There was 1 year where they made the dates current. People ended up preparing their medicals, preparing all their forms and everything. And they were ready to file with USCIS. And USA just came back saying there was a mistake with the visa bulletin and they retrogressed. So people have also gone through that kind of that kind of things with USCIS, right? That kind of history with USCIS. So 2020 was really awakening for all of us. 2020 dates became current. They moved quite a bit. EB3 people had an advantage where dates moved further than the EB2. So those good things happened. People were able to file their cases. In fact, a lot of kids who were aging, they also got the advantage and probably, may have got their green cards by now. So 2020 was good. People filed their green cards. People got their green cards probably in a year's time. I mean, myself, I filed so many cases and a lot of people already got their green cards, right? Including the principal applicant and the derivative applicant. Now, the dates kept moving on. Obviously, it's retrogressed this from October, right? So the good advantage was that when people file their green card, some of them who've already got it, great, they've already in their green card status now. But people who've actually filed and are still waiting, they get their AP and EAD card. So that actually works in their advantage, right? If there are kids and their dates are current as per table A, then eventually the kids' age is protected, which I think Diya will talk more in depth. But, those advantages are there by just filing the AOS. So just considering that they've had a history, and I'm sure things will continue to move forward, but we don't know when, because USCIS is very unpredictable. Like looking at the 10 years history, they're very unpredictable, but I'm sure there is hope and the dates will move, and we're just hoping that India will benefit from this.
Right. You mentioned about a lot of kids got protected under CSPA because of the whole filing of AOS. Diya, I want you to go a little bit in detail there, and I want you to talk about the whole CSPA and what happens to people who are now whose dates are current right now in September, but looking at the October visa bulletin, their dates will retrogress. What will happen to them?
Yeah. So the Child Status Protection Act, and basically what it does is that it locks in the child's age as of the date of filing of the adjustment application. If the adjustment application was filed based on Table A, right? So it's important to note that the CSPA protection doesn't attach if the adjustment application was filed based on Table B of the Visa Bulletin. But let's say for somebody who, let's say in October 2020, right? Because many people filed based on Table B at that time, because Table B, USCIS was accepting Table B applications in October 2020. So at that time, for somebody who filed and subsequently the date became current according to Table A, right? For a child like that, the protection would attach from the date that the priority date became current according to Table A. So the good news is that even if there is retrogression, after the priority date has once become current according to Table A, then the child remains protected. So let's say the adjustment application was filed and the child's age was 20 years old at that. The child was 20 years old at that time, right? Even if there is retrogression, and by the time the adjustment application is finally adjudicated, let's say the child is 26 years old age, right? The child is still protected.
Oh, okay.
Okay. So that's how it works, as long as the child has not married in the meantime.
All right. So we do have a question here. Kids' age will be logged based on the state of filing, the date of filing, or final date. So I think the final action date is Table A.
Final action date. Yeah. Table A. Table A is final action date. So that's what matters for Child Status Protection Act.
So if you're, you file for your adjustment of status in using filing date, your child is not protected. But
not protected at that time. Yeah, not protected at that time. But if the child was still under 21, when the priority date became current according to Table A, then the child's age is locked in.
All right. I hope it answers our audience's question. We have another question from Prem. Any chance of getting filing dates to November 2015 in fiscal year 23?
That's the $1 million question, right? And I think we have all learned the hard way not to give any predictions on priority date movements. So, yeah, unfortunately, I think I think the advisory that came with the Visa Bulletin also says that they're not expecting too much of a movement with the priority dates for the next fiscal year. So I don't think it's going to be as dramatic as it has been the last couple of years. Right. But who knows? I think the advantage that, people born in India had was the spillover from the family categories, right? Because there were practically no interviews happening at the consulates in the last couple of years. So if that continues, I think there is a possibility that, there might be additional numbers allocated, but otherwise I don't expect the surge to be dramatic.
Yeah.
All right. I also, a lot of people have this question, and I'm just going to ask it for them. What happens to cases who were interfiled, right? They interfiled in EB2 category. So what happens to their cases if the dates kind of retrogress in EB3? Do they have to refile? Do they not get their green cards? It's confusing.
Yeah, that's a great question. And in fact, I personally had a lot of clients ask the same question. So, going to repeat it, the question is when they put in the interfile request with USCIS, right? And USCIS had announced that particular location, Montclair in California, where you sent in your interfile request, that is to be considered in EB2. So the question is, when you put in an interfile request, are you giving up your adjustment in EB3? And are you then only counted in EB2? And the answer to that, I would say, is no. I mean, with the interfile, basically what you're doing is you're giving USCIS the authorization to approve you in either category, in EB2 or in EB3, whichever is more beneficial, right? So it doesn't automatically, just take you out of EB3 and put you in EB2. In any case, the interfile request is finally adjudicated only when the green card is issued, right? So it's not that, just by putting in the interfile request, it's not that they're moving you into the EB2 category. It depends on, what the priority date movement is like when they actually adjudicate the case, and then they can decide whether to approve you in EB3 or in EB2.
All right. Thanks for that. And, another trend that I'm noticing is in many cases, the primary applicant gets approved, they get their green card, but not the dependent. What happens in that case, with this October retrogression? What happens to those cases where the primary applicant got the green card because their dates were current, right? All the applications were filed at the same time, But now there's no adjudication for the derivatives right now, and the October Visa Bulletin has already arrived. What happens in that case?
Yeah, Deepika, you want to talk? Or I can just say, so I have never seen this before. This is something very unique to this season, I would say, because in the past, right, Deepika, like the family adjustment applications would be all adjudicated and disposed of together. We never really had situations where some, like the dependents were left behind and only the principal applicant adjustment was approved. This seems to be like a trend this time, and I don't know why. I thought maybe this was something to do with the visa number usage. Maybe they just wanted to consider the principles towards the visa numbers and maybe change, how they use up dependents, the visa numbers for the dependents. But I think the latest clarification from USCIS says that, this is it. And if the dependents are not approved right now, they might just have to wait. Doesn't really make sense. It's, absolutely nonsensical. So, I'm telling my clients to wait until the end of the month, right? Because it's several cases, where the dependents are not adjudicated. So let's wait and see. And if not, then maybe we could consider, whether it makes sense to do an F2A, the family-based petition, which is a pity. I mean, it shouldn't be that, somebody has to file an F2A, but that might be one of the things to do. If we'll have to take a call on it. But in any case, the dependents are, for the time being, the dependents are fine because they have the advance parole and the EAD. So they can continue using that. They're not going to fall out of status or anything. There's no immediate cause for concern. And the CSPA protections would also apply for the children if, they were eligible in the first place. So it's not all bad, but just very unusual for USCIS to operate in this manner.
So it is highly unusual. I mean, whatever we've been seeing in the last 2 years or so, it has been unusual. The retrogression is unusual. But one thing that I really want to understand from you, Deepika, is the correlation between adjustment of status and EAD. How do they correlate to one another, especially, someone in the EBs and the L1s categories? How does that work? And then does one have to renounce their H1B? I mean, there's so many questions around it, right? What happens to their H1B status if they travel, if they use their, the EAD-AP combo card to travel outside of US? And then, so if you could just go into a little bit of detail there and, explain what happens to the EAD-AP and what's the correlation with the AOS here?
So Neha, see, H and L both are dual intent visas, right? So when you come on an H and L visa, you can definitely go into the green card process and file a green card for you, which probably are not there for some other employment-based categories. So what happens is when an AOS is filed, you also have the option of filing a EAD card as well as an advance parole along with that application. Now that's by choice. It's not a mandate, but you do have the option of doing that. And what it does is EAD cards allows you to work. It gives you the flexibility to work, and the AP card allows you the flexibility to travel in and out of the United States. It basically oversees the requirement for the visa. So people can still maintain their H1B and their L statuses in the US. So H is not an issue because obviously you have an I-140 approval. You can continue to file extensions. If your priority date as per the H1B I-140 is current as per table A, you cannot extend your H1 for 3 years, which you could do if it is not current, right? So you can only extend for 1 year and you can continue to do those extensions, which USCIS is approving, provided you are in the United States of America. If you're outside the US and you're trying to do a consular, you may not get an approval because your priority date is current as per table A. Now for the Ls, what happens is you have this limit of 5 years on L1B and a 7-year on L1A. And obviously the I-140 doesn't help you to extend further on your, on your term. So then if a person is on L1A and is really close to the 7-year exhaust period, then you have no choice. You have to switch to an EAD and use your EAP at all times to travel in and out till your green card actually physically is approved by USCIS. So that basically is what a person has to look into. If you have an H1B and you have an option of extending 1 year at a time, I would recommend doing that, because if something goes wrong with your H1B in any time where you've worked with a number of companies in your last so many years, right? If something goes wrong ever, you at least have an H to fall back on, right? If your 485 is getting denied for whatever reasons. But for the Ls, they don't have an option. They need to make sure that an AP and EAD is maintained at all time. You're filing an extension in a timely manner. Especially because of COVID, the adjudication for AP and EADs is almost like 6 to 7 months, right? Even though EAD has the benefit of doing automatic extension and continue to working, the AP does not. You have to have physical AP approval before you actually travel outside the US and you want to re-enter, because that's the only thing which will allow you to come back to the United States. So that is the advantage you have when you file an AOS, AP and the EAD, and then continue to file extensions and maintain your non-immigrant visa wherever possible. That's advantage.
Deepika, we've seen recently that USCIS hasn't really been issuing the combo cards. Some cards have just been EADs.
Yeah.
The AP combo isn't happening. So what happens to them?
Yeah. So there was a time when they were offering the combo card, which was actually very good because the EAD and the travel was together and they just had to carry that one card in and out of the US, right? Now then suddenly USCIS, I think last year they switched to having an EAD card separately and the AP again, the paper form, right? Now we don't have a choice. I don't know why the delay is there for the AP. Well, EAD comes, people are getting EAD cards within 6 to 7 months, but the AP is taking a little longer. I'm not what has added to that delay. I mean, obviously we have COVID as one of the magic words, which adds, to everything for all delays.
USCIS has been using liberally, actually.
Yes. So I'm not sure if COVID is the reason for the AP delays, but yeah, I mean, that's what we've been telling everyone, that there is a delay from USCIS overall on all kinds of adjudications, and so AP, unfortunately, it is separate. They are two separate applications. They are adjudicated separately. You get a EAD card versus AP comes in a paper form. And if you need an expedited AP, say you have an emergency travel, there are definitely options, and we've been very successful for people getting that also. It limits to like 30 days to 90 days. Officers give it to you for like on an emergency basis. So get in touch with anybody, any of your lawyers or your legal counsel, and they can help you to get that expedited.
All right. Thank you for that. We're literally in the last few minutes of our discussion today, but I want to take up some of the audience questions that we have here. There's this one question. They're asking, we filed for adjustment of status, went through the interview. What happens to my case in October if the decision doesn't come sooner than that? Who wants to take it?
Yeah, so the visa number is not current, right? And I think we've experienced this even in the last few days for people who are interviewed in September. In the last few days, apparently at the conclusion of the visa interview, the officer would actually tell the applicant that we are out of visa numbers, and so we are going to put your case, on hold. On hold in the sense that the adjustment adjudication will not continue. It is going to be put on hold until the priority date becomes current again. But all other benefits, like the EAD and the advance parole, all those benefits will continue. And so, the applicant should just continue renewing those in a timely manner. And they can also change jobs based on the AC 21 portability rule. If need be, they can utilize that also later on. So, it is not the best news, obviously, but at least, you have your adjustment application in.
Right. It almost seems unfair, right? where these numbers were projected, people file for their adjustment of status, and then suddenly USCIS wakes up one day and says, oh, sorry, we don't have these numbers anymore. Seems unfair. Right.
And just to add, Neha, to add another thing to Diya's thing, that, 485 interviews have actually increased. In the last 1 year, we've seen as COVID is getting a little more relaxed, we are seeing that 485 interviews have increased, and USCIS officers are calling people in person, for interviews. So I think next year we are going to expect much more interviews happening. So people have to be prepared with their paperwork and a little more pre-planned for, if this happens to them. So that's the next thing. I mean, we're going to see a lot of different things happening next year, I'm assuming.
Yeah. All right.
In the meantime, get their birth certificates and those kind of documents in order. The big, I think one of the biggest showstoppers for internationals is the birth certificate from India, right? Having it in the right format from the municipality. So make sure you have all of that ready and in place before the date becomes current again.
Yeah, and we had the discussion a few months ago about how to access your, birth certificate in case you don't have one, and while filing adjustment of status, you don't want to fall into any more delays. We have one of those videos. If you go to our YouTube channel, you should be able to find that. One question that comes up, and it's very amusing. Do attorneys have access to the list from USCIS that they'll issue green cards to so and so people. Do you have?
I wish.
Do you guys
I
have
wish.
a list?
I would pay a lot of money for that list. But no, unfortunately, no, we don't.
Yeah, we don't.
No one knows.
We don't.
what
We have no
USCIS is
secret
doing.
information from USCIS.
No one knows what's happening. All right. I think we have time for a couple more questions and then we'll just start wrapping up. This one question comes in. Priority date is October 2013. I filed for adjustment of status in June. Haven't received EAD and there is no information about what's happening to my case. Should I be worried because of the October Visa Bulletin?
So they filed in which month again?
In June. In
June. So just like 4 months ago.
Yeah. And they haven't received any information from...
Yeah. So no, the case, I mean, the first, I guess the only thing they would expect to be done with at this point is fingerprinting, the biometrics. And even that in some cases can take longer. But I think the advance parole and EAD would take at least 6 to 7 months, as Deepika explained. And so the case is still within the normal processing time and there's nothing to worry. I mean, of course, if the date is not going to be current next month, then, we cannot expect the 485 adjudication to take place, but advance parole and EAD, the interim benefits will continue to be available.
What will be your advice to people, whose dates are still current until September 30th? Should they be waiting for an RFE for medicals or should they be submitting their medicals along with, does that impact their case, the speed at which the case is processed? What's your advice?
It's, we struggle with this question because USCIS advisory is to not try to submit the medicals proactively, but to wait on the RFE. But a lot of clients, they've obtained the medicals anyway in the anticipation of an RFE. So I know that many of them, despite our advice, they are actually going ahead and just submitting them to USCIS. And we'll see, because I think the challenge for USCIS is that sometimes the cases are moving between the service centers. And so you send it to one location, USCIS is not able to guarantee that they will match it to your file. But I guess, for many clients, they just want to be able to do whatever they can from their end, right? So, if they want to send in the medicals, I guess, they can do that. And in terms of whether, that will help before the end of the month, I think based on everything that USCIS has announced so far, it's probably going to be pretty unlikely that, that anything will happen, right? I know that sometimes a lot of people are assuming that USCIS might have set aside a visa number by the time they issued the visa, or if there is an RFE, then maybe they took a token or put aside a visa number. As of now, there isn't anything to support that. So, I guess we'll just have to wait and see.
All right. I have two
also
more
to add,
yeah, sure, Deepika.
Just to add to Diya's thing, right? And getting an RFE for the medical is actually a good sign. That means they probably are looking at the case, or they're kind of like, in the process of reviewing the paperwork or whatever. So I think waiting for the RFE is obviously an advantage, so that their medicals, if they just send in, it doesn't get lost, especially because how Diya mentioned, right? Cases get traveled from one service center to, maybe a service center to NBC and things like that. So I guess it's good to wait for the medical before, get an RFE for the medical before they send it voluntarily. So that's what we would recommend. Other than that, as Diya mentioned, right, we really don't know what's going to happen. They just have to wait and keep maintaining their H1B, keep maintaining their AP and EAD extension so that they don't have like any kind of interim period where they don't have work authorization or something,
Right.
That's
There's
something.
one question related to that, Deepika. Is the EAD AP for a limited period of time? Is there a wait time to renew it? Like how long does it take to renew an EAD AP?
Right. So EAD and APs are usually, these days, they kind of give it for 2 years. That's what I have seen in most of the cases. Typically, an EAD can be extended 180 days before expiration. So once your EAD is expiring, 180 days before is when you can kind of extend it. If you file an EAD extension in a timely manner and say you don't get the EAD, the next renewal available, you have an automatic extension period provided by the USCIS. So even if you don't have an EAD, extended, you can still continue to work based on the timely filing, So that is an advantage you have. As far as AP is concerned, you can only file an AP 120 days before of expiration. So that probably takes a little longer time. So it's like, 4 months before, and then you have to wait for another couple of months to get the AP. So for the AP, I would just recommend that if you have a travel plan, you will have to first make sure that you have an AP in hand before you make any travel plan, especially if you're basing your life only on your AOS. Right? If you have an H1 and L as a backup, you can still go for visa stamping and you can, come back because it's dual intent. But if you're basing your life only on AOS, please make sure you have an AP in hand before you make any travel plans.
Well, visa stamping is another challenge as we know it.
Absolutely.
So it's not easy. One last question, and we're going to wrap up this show. There's this question, and I think, Deepika, you should answer this. My file was transferred to San Bernardino field office on July 18th, and there's no update since then. My husband's file was transferred to Los Angeles field office on June 1st. We got our medical RFE on July 5th. We responded. Status changed to correspondence received, and USCIS is reviewing it on July 14th. And since then, there's absolutely no update on the case. How will this retrogression impact my situation?
As we've mentioned, right? If there's already a visa number allocated to them, then probably they'll get their green card. If it is not, then they have to wait for the next visa numbers available. And, basically, there's no visibility, to be very honest. We don't know whether they will fall in before September 30th, they will get their green card, on whether it will get pushed on to the next fiscal year. To be honest, AOS is all a wait time. Even in 2020, when people filed, we told them that, hey, you just file it. We don't know whether you will get the green card. But apparently people were getting green cards in 2 months. Adjudications were happening in 2 months. And I saw people getting green cards and approvals in 2 months, right? So I would just say it's a time to wait. I mean, we don't know whether it's been allocated to them already or not. They can continue to keep checking on USCIS website, keep opening service requests to know where their case stands, probably even go through EMA and check what is happening with their case. But I would just say hang in there. I mean, eventually the green card will come. That's the hope I see.
Well, that's the hope you see. But what is your advice to those who see absolutely no hope? No one really knows what the backlog is going to look like now, right? Yeah. And I believe there's a backlog within a backlog now, because there's still so many people who haven't received their green cards. They only have their EAD APs. We don't know when the priority dates will get current next for those born in India.
So Neha, usually... Yeah, sorry to interrupt, but usually by the next fiscal year, there is always some news. And I think, after October, there might be even the agency, USCIS and Department of State might also have some more visibility. So I'm thinking by the end of October, or by the time the November, bulletin is going to come out, we will have an idea of, what to expect in the next few months.
All right. We are all hopeful for that. I really want to thank you, Deepika and Diya, for taking out time today. I mean, this was very last minute. We planned it out in a very last minute fashion. But thank you so much for, answering all these questions so patiently. And thank you to all of you who've joined us today for our special live. We will see you again on Thursday with another attorney. Likely it'll be Deepika. We'll be talking about another topic. So we'll see you then. And if you have any questions for us, any comments for us, send us all of those to info@chug.com. Stay safe.
Thank you. Bye.
Bye-bye.